Hi, my name is Kelli Gordon, and I am partner with the law firm of Feldman Wasser in Springfield, Illinois.
And hi, I'm Ashley Davis. I'm also a partner at Feldman Wasser in Springfield, Illinois.
Today, we are going to talk about the new maintenance statute effective January 1st, 2019.
Now, Kelli, we know that there are changes coming to the maintenance statute, but before we start talking about the changes, can you tell us a general idea of how a court determines that a case is a maintenance case?
Sure. In accordance with Section 505 of the Illinois Marriage and Dissolution of Marriage Act, the court must first determine whether or not it is in fact a maintenance case. And in order to do that, there are the 14 relevant factors that the court must analyze to determine whether or not there is maintenance.
So once there has been a finding that maintenance is appropriate, then what?
Once the court has looked at those 14 factors and determined that maintenance is appropriate, then the court's going to decide whether to use guideline maintenance or non-guideline maintenance. With non-guideline maintenance, the court isn't going to look at the specific formula, which I'll discuss in a minute. Instead, the court's going to come up with a finding and determine what non-guideline maintenance should be. For example, if the party's gross income is greater than $500,000 per year, then the court can use the non-guideline maintenance. In addition, if the payor's maintenance and child support payment is greater than 50% of his income, then the court can also use non-guideline maintenance at that point as well.
Now, the IRS has changed the law with respect to maintenance in 2019. Can you explain how its treatment of maintenance is different?
Yes, and that's where the formula comes into play. The formula was previously that you take 30% of the payer's income and then you subtract out 20% of the payee's income. Because of the change with the IRS and that now maintenance will no longer be includable to the payee in his or her gross income and no longer deductible to the payor in his or her gross income, the numbers have changed a little bit in terms of the calculations. So now instead we're going to use net income opposed to gross income. And so it's 33.33% of the payor's net income minus 25% of the payee's net income. And then we still do have what we refer to as the 40% check, meaning after the maintenance amount and the payee's income, if that net income is greater than 40% of the aggregate payee and payor's income, then the maintenance guideline is lowered to reflect that amount.
Now, Kelli, what if a maintenance order is being modified?
That's a really good question. So if an order has been entered prior to December 31st of 2018, then that maintenance can still be deductible and included as income. So if someone files a motion to modify that order and say the hearing is held in February of 2019, then the court's still going to use the old calculation, the 30% and the 20% of the payor and the payee's gross income. And the only time that it would change is if both parties expressly state that they are using the new calculations. And with that, with the taxes as well, it's still going to be includable and deductible.
Now, are there different types of maintenance?
Yes. There's always been the fixed term maintenance, which is when the court orders maintenance for a specific amount of time and then it's barred after that. So for example, 5 years and then the maintenance terminates. Now with the new changes, there's also indefinite maintenance, and indefinite maintenance is where there's no termination date. And instead that maintenance is going to be modified or terminated pursuant to Section 510. And then there's also now reviewable maintenance. And reviewable maintenance is for a specific amount of time, and then it's supposed to be reviewed at that specific amount of time.
And what are the definitions of gross and net income that the court uses?
Gross income is going to have the same meaning as Section 505, the child support statute, except that Section 505 talks about income as including maintenance. So obviously on this statute, you're not going to include the maintenance. And then same with net income. Net income, they refer back to Section 505, and it'll be the same except maintenance payments in the pending case are not includable. We hope that this has helped you get ready for the upcoming changes in the maintenance statute effective January 1st, 2019. To learn more about upcoming family law statutory changes, visit the ISBA Family Law section resources on the ISB website. Thank you.
Thank you.